Today, I am taking your
You are not
session.
audible.
You are audible, ma'am.
Am I audible?
Yes, yes.
Okay. Anjali, is it fine? I hope there is issue with Anjali's system. I think other participants are getting my voice, right?
Yes.
Thank you. Thank you. Okay. So good afternoon, everyone. Today I am taking a session on unlock pre-pack procedures, legal framework, and practical insights. Um, Before starting this session, as this is the initiative on Women's Day, which ICSI IIP is doing, and they want me to share my perspective on experience for women in corporate world. So I would definitely say that there is always some difficulties and challenges uh, women face while balancing both the work and life at a certain stage of their life. But still, if you have positive outlook and you want to get something, so you will definitely balance both the things and achieve in corporate world also. So with that short uh, uh, short thought on this, I would like to quickly go to the today's topic: unlock prepack procedures, legal framework, and practical insights. So first of all, I would like to start from the basic. I know everyone here already know about the prepack, but still, if I'm taking so I should. I'm taking this topic, so I should start from the basic first. So, first of all, what is prepack? So, prepack, this term has not been defined under IBC Act. Uh, there is no statutory definition of pre-pack under IBC code, uh, but it has different nomenclatures used in different geographies. Like in USA, it is termed as pre-arranged insolvency resolution. In UK, it is called as pre-planned sale in UK. Similarly, in Singapore, it's scheme of arrangement, like that nomenclatures. So, but from the term itself, it is you can understand that pre-pack is a pre-arrangement before going to the NCLT for sanctioning for sanctioning for resolution. It's a pre-arrangement from the creditors and debtors side uh, before filing insolvency petition. So lots of work already done beforehand, before getting approval sanction from NCLT in pre-pack. So the main objective of pre-pack resolution process is to provide an alternative insolvency resolution framework. There is already a CIRP process since inception in the IBC, but PPIRP was not there when CIRP was notified. IBC was notified. It eventually evolved, and during COVID-19 period, there is a need there is a need felt for introducing some quicker and simpler framework for MSMEs uh, to get to give them relief from the distress due to COVID. This pre-pack insolvency resolution process was introduced under IBC. So actually, it's a mix of informal and formal insolvency proceeding. What we call it, why we call it as informal? Because it is a in informal process. There is debtor creditor go for out of court settlement first, and in formal process, they have to take the approval of NCLT, and this is the blend of both. Over here, debtor and creditor also approve some base resolution plan, and then they go for NCLT for their sanction, their approval. And this is something a little bit about the basic of pre-pack, or you would say the term why this pre-packed word is used for this thing. And as I said, what is the need for PPIRP when there is already a CIRP process in the IBC? So this need, it was felt in during the period of COVID-19, where government had took various measures to give immediate relief to corporates. And they have initially the minimum threshold limit was 1 lakh rupees, and they increased that limit to 1 crore during that time, from 25th March 2020. uh, with effect from 25th March 2020, they have introduced Section 10A, which suspended any insolvency proceed all insolvency proceeding for the defaults occurred during that period for 1 year, from 25th March 2020 to 2021. And other than that, what government has done is they have felt, because MSMEs, lots of business got affected, and MSMEs also affected a lot. And due to the increase in the threshold limit of 1 crore, lots of MSMEs could not get take the route of CIRP process. So this PPIRP PPIRP pre-pack insolvency resolution process was introduced by notifying new chapter 3A in part 2 of the IBC, Insolvency and Bankruptcy Code, from which date? From 4th April 2021. So from 4th April 2021, this PPIRP framework was introduced, and PPIRP framework was introduced, and they have also specified the minimum amount of default for 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 this PPIRP process would be 10 lakh. That means for 1 crore and more, you can go for CIRP process, and for below 1 crore, you can go for 10 lakh if the corporate debtor is MSME. So this was the need, I would say, because of which PPIRP was introduced in IBC. So what is the benefit of PPIRP? It is uh, considered as more easier way for resolving the insolvency, because of it has the characteristic of both formal or and informal proceeding of resolution. Uh, uh, Preliminary work already done by the management before applying to adjudicating authority, and creditors also give their approval for the base resolution plan, and management of the corporate debtor remains with the corporate debtor, because in MSME sector, uh, in which is in MSME sector, which is wherein not lots, the business is not that huge, and promoters know everything about the management of the corporate debtor. So it was at that time, it was felt that that debtor in position remain with the existing management, means corporate debtor remain with the existing management. It should not be vested with the resolution professional, just like the process, just like in the CIRP process. So corporate base resolution, there is also a Swiss challenge method, wherein if base resolution plan is not considered appropriate by the COC, then COC may invite resolution applicant for submission of resolution plan, and then from the comparison of both, the best resolution plan is considered by COC. So it's a faster resolution, and and since NCLT comes quite later, after lots of work done by the management itself, it reduced the burden of NCLT as well. So background of PPIRP. So this concept was initially introduced by ILC, Insolvency Law Committee. They decided to constitute a subcommittee to study PPIRP on 16th May 2020. On 24th June 2020, subcommittee of ILC for PPIRP was constituted under the chairmanship of our former chairperson, first chairperson of IBBR, Dr. M.S. Sahu. Then MS Sahu led committee submitted their recommendation on PPIRP on 31st October 2020 and prescribed the PPIRP framework. Based on their recommendation, on 4th April 2021, an ordinance was issued, which later converted into IBC Amendment Act on 11th August 2021, which became effective with retrospective effect of 4th April 2021. Accordingly, with this amendment, Chapter 3A in Part 2 of IBC was introduced, and Section 54A to Section 54P. Around 16 sections were inserted. Minimum threshold, minimum amount of default was notified under Section 4 of IBC, which is 10 lakh. And on 9th April 2021, IBBI notified regulations and rules on pre-pack insolvency resolution. And next. Uh, okay. Then I have put up here extract of subcommittee of ILC. Why they have mentioned here the need for introducing this. I have highlighted here that the government of India has taken several measures to ameliorate the pain emanating from COVID-19. It has increased the threshold of default for filing an insolvency application from 1 lakh to 1 crore to prevent MSME from being pushed to insolvency. And then the court made another course correction to suspend filing of application for initiating CIRP during this period, and can be extended up to this. And this insulated a company which did not have a default on this but commit default. So this IL subcommittee has mentioned these measures in their report. And so first of all, we are saying that this is applicable for MSMEs. So what is MSME? What all businesses are covered under MSMEs? So MSMEs are the businesses that which are characterized by a specific threshold of investment in equipment and annual turnover under MSMED Act. So PPIRP is restricted to MSMEs, which are only companies and LLPs. Other MSMEs like sole proprietorship firm, partnership firm, HUF are not covered under PPIRP. Means only corporate person can go for PPIRP process. So these are excluded from this PPIRP process. Recently, in last 21st March 2025, Ministry of Micro, Small and Medium Enterprise has revised MSME definition, classification criteria of MSME to include more inclusive framework for enterprise categorization based on investment and turnover. So what they have revised is for micro enterprises, investment limit in plant and machinery should be up to 2.5 crore. For small enterprises, the investment limit in plant and machinery should be 25 crore. And for medium enterprises, its investment limit is rupees 125 crore. This is the increased limit with effect from 1st April 2025. For turnover limit, you can just to remember this limits, you can multiply by 4 to the investment limit, and then the turnover limit will come. Uh, um, 2.5 crore for macro and 10 crore for turnover limit. For small enterprises, investment limit is 25 crore and turnover limit is 100 crore. And for medium enterprises, investment limit is rupees 125 crore and turnover limit is 500 crore. So based on that, all businesses, which are companies and LLPs, whose investment limit and turnover limit both should should come under this criteria. Then only they can take the benefit of MSMEs. So for other than this, there has to be for MSME, for proving themselves as MSME, when you apply for application, PPIRP application before the NCLT in Form 1, there is a prescribed Form 1. Uh, uh, they have mentioned lots of annexures to be enclosed with the application, and one of the annexure is proof such as Udyam registration certificate. MSMEs in India, MSMEs has to register themselves at Udyam registration to get them benefit of MSMEs introduced, to get that all those benefits that government introduced for them. So they have to get this Udyam registration certificate. So either they have to get this Udyam registration certificate as proof as proof of them as MSME, or they have to attach the proof of their investment and turnover with the application. Uh, so legal framework. Uh, in this PPIRP, as I have mentioned that a new chapter was introduced in the Insolvency and Bankruptcy Code, Chapter 3A, which was effective from 4th April 2021. Uh, in this, 16 sections were notified. So Section 54A to Section 54P. These sections are covered for PPIRP. Other than that, there are regulations, IBBI, Pre-Pack Insolvency Resolution Process Regulation 2021, and IBBI, Pre-Pack Insolvency Resolution Process Rules 2021, and other applicable provisions, which are applicable on CIRP will also be applicable. Some of the provisions will also be applicable uh, to PPIRP process under Section 54P, which is last section wherein number of sections are prescribed, which will, of number of section of CIRP process are prescribed, which will be mutatis mutandis will be applicable to the PPIRP process. So there are 19 sections. There are 16 sections, but 19 sections were added during that time. Section 11A, Section 67A, Section 77A, and these 16 sections, PPIRP rules and regulations through this amendment ordinance. So let me just give you a broad overview of provisions or PPIRP framework. Section 54A. Section 54A talks about the eligibility criteria of corporate debtor. There are certain conditions which you have to be fulfilled before applying for PPIRP process. Uh, these conditions include that corporate entity should be MSME, and they should not have undergone for CIRP or PPIRP process in last 3 years, or they are not undergoing with CIRP process. No liquidation order is passed against them, and similarly a minimum default is not minimum default is 10 lakh. Some and financial creditors have given their approval, something like that. All these conditions we will elaborately study in section 4A, section 54A. uh, I'm just giving a basic overview of this framework. And section 54B talks about duties of IP before initiation of PPIRP. So over here, before initiation of PPIRP, when PPIRP will initiate, just like in CIRP, CIRP commences from the date of admission of CIRP application. Similarly, in PPIRP, the PPIRP initiate or commenced from the date of admission of PPIRP application by the adjudicating authority. So before initiation of PPIRP, the IP which are proposed by the directors and financial creditors to become the RP, they have also some duties, like they have to prepare a report wherein they have to mention that corporate debtor has fulfilled all the eligibility criteria under section 54A, and uh, uh, and the base resolution plan which is the prerequisite, means from the beginning itself, corporate debtor has to have a base resolution plan which is approved by the financial creditor also. So IP has the duty to declare that they have fulfilled the requirement of base resolution plan also, along with the eligibility criteria. So this is the pre-initiation of PPIRP process. Before initiating PPIRP, these two sections provide that these arrangements should be done. And section 54C talks about application to initiate PPIRP. So, after fulfilling the provisions of 54A and 54B, then a uh, corporate applicant or corporate debtor move on to apply to initiate PPIRP by filing a prescribed form, which is Form 1, with the filing fee of rupees 15,000, along with all the annexures which they have created in 54A and 54B. Uh, as I mentioned that this is a pre-arrangement wherein financial creditor and creditors and debtors both agree for a some base resolution plan. So board of directors give their declaration that under section 54A, what they under section 54A, all major stakeholders like creditors, directors, and shareholders give their approval for initiating PPIRP process. So all these approvals, declarations, and base resolution plan, this report by IP, all this have to be annexed with this application under section 54C. And then comes section 54D, which talks about timelines for completion of PPIRP. So PPIRP was introduced for providing the faster resolution. So they have mentioned that there will be the maximum time of 120 days for completion of PPIRP. Means, and there's no extension, just like in CIRP, there is total time limit is 180 days, then 60 days, 180 days, and then how many days? 90 days extension and then 60 days. Let me just um, total 30 days is provided with extension. So there, in this PPIRP case, there is no such as extension. Um, PPIRP has to be completed within 120 days only, and out of this 120 days, 90 days is given to COC and resolution professional to approve the resolution plan and submit to adjudicating authority, and 30 days is given to sorry, and 30 days is given to adjudicating authority to approve that resolution plan. So, but out of 120 days, there is 120 days is bifurcated in two parts. One is 180 days and another is sorry, 120 days. Uh, Out of 120 days, 90 days is for uh, RP and COC, and then um, 30 days is for this adjudicating authority. Then at the time when application is moved to adjudicating authority has time of 14 days to either accept or reject the application. When it accepts the application, it declares moratorium and appoint RP. NCLT do three things: declares moratorium, appoint RP, and cause public announcement within 2 days of commencement of PPIRP. So this is section 54E. Section 54F talks about duties and power of RP during PPIRP process. So there are duties prescribed like um, to obtain the list of claim, to update the list of creditors, to convene the meeting, to attend the meetings, all meetings, to monitor the management of the affairs. Over here, the word monitor is mentioned for managing the affairs of the of the corporate debtor. That means in CIRP, once the CIRP process commences, the board of directors suspended and the management get vested with the resolution IRP vested with the IRP, insolvency resolution professional. But in this scenario of PPIRP, since existing management continues, so uh, there is no suspension of board of director, but RP has the duty to monitor the management of the affairs of the corporate debtor. So all these things are mentioned in section 54F. 54G talks about list of claim and preliminary information memorandum. These two things are to be provided by corporate debtor to the resolution professional who is appointed within 2 days of commencement of PPIRP, providing the list of claim and preliminary information memorandum of the corporate debtor. Based on that, it will update the RP will update the list of creditors, inform them about their claims, and then get the claims and prepare the final information memorandum. So 54G talks about that. 54H talks about management of affairs of corporate debtor, as already mentioned. As already discussed, that management of affairs of the corporate debtor continues with the existing management only, and RP, it does not get transferred to RP, and RP just has to monitor the affairs of the corporate debtor. 54I talks about committee of creditor. Committee of creditor, just like in CIRP, comprises of financial creditors only. Financial, but unrelated financial creditor. If financial creditors are related financial creditor, then it will not be the part of COC, committee of creditor. If in case there is no financial creditor, or I would say there is no financial creditor, or if all financial creditor are related financial creditor, then top 10 operational creditor of the CD will constitute the COC, and in that, one representative from the workman and one representative of employee will also uh, be the part of COC in that scenario. 54J talks about vesting management of CD with RP. This is exception which I was talking about earlier, that management is not uh, shifted to RP. But over here, if COC says that there is some things happening which is not appropriate, or mismanagement is happening, so in that case they can apply to um, adjudicating authority, and adjudicating authority can direct vest the management to the RP. So this is 54J. 54K talks about consideration and approval of resolution plan. As mentioned, from the beginning itself, directors and creditors have their base resolution plan, which they approve with financial creditors also beforehand, uh, uh, before going to the initiate this PPIRP process. But in case COC wants to improvise this base resolution plan, or invite resolution applicants for better resolution plan, they can do so. And accordingly, both all plans are get compared based on the evaluation criteria prescribed by RP. Sorry. And the best resolution plan uh, is uh, uh, is evaluated by COC and forwarded to adjudicating authority. Under section 54L, obviously, once COC approve the resolution plan, that approved resolution plan is provided to submitted to NCLT within 90 days of commencement of PPIRP, and adjudicating authority has 30 days time to either approve or reject that plan. 54M provides, if there is any appeal to be um, filed against the order of 54L, that can be filed under section 54M. And 54N talks about termination of PPIRP. Over here, if after initiation or after commencement of PPIRP, but before approval of resolution plan, COC thinks that the PPIRP should be terminated, then it can go for uh, application by filing of form P14 to adjudicating authority for considering this termination of PPIRP. And section 54O, initiation of CIRP. Over here, PPIRP get converted into CIRP on the application of COC. So there is a process prescribed under section 54O. Section 54P talks about applicability of CIRP, some of the CIRP provision to PPIRP. So these are broad overview of all these 16 sections which are covered, which talks about PPIRP process. Let me just... a snapshot on PPIRP process. So let me just give you a snapshot first before delving into each section of PPIRP process. First of all, an application and for PPIRP is moved by only MSMEs, corporate applicants. Corporate, who will be covered under this? Corporate applicant. Corporate applicant means either company or LLP only. And unlike in CIRP, where application can be filed by financial creditor, operational creditor, and corporate debtor under section 7, 8, and 10, 7, 9, and 10. In this, only corporate debtor can file the application of PPIRP. That means, in case of default, creditors cannot file PPIRP process, file for PPIRP process. Only corporate debtor can take this initiative or file this PPIRP application. And MSME means MSME as defined under section, as classified under section 7, clause subsection 1 of MSMED Act 2006. So there are some pre-MSMED Act. I have already elaborated the classification criteria of MSME Act earlier. So all those business entities will be covered under this MSME under section 7. So what are the precondition? Precondition, I have already give a brief about precondition. One second. So first of all, CD has not undergone PPIRP or CIRP during the last 3 years. It says in last 3 years, it has not undergone. There is a cooling period of 3 years, you can say. Only after that you can go for this PPIRP. And it is not currently undergoing CIRP. If already CIRP process is undergoing, then PPRP process will not get started. If liquidation already order has been passed, then also CD cannot go for PPIRP process. Section 29A, corporate debtor is eligible to submit the resolution plan under Section 29, and there are certain criteria defined under Section 29A of Part 2 CIRP process, wherein what all cannot uh, submit the resolution plan. So it is eligible. One of the condition is all that also. And unrelated financial creditors have proposed and approved the name of RP with 66%. Means at least over here in under the regulation, it is mentioned that at least 10% of unrelated financial creditors have proposed the name of IP to be appointed as RP, and at least 66% of the financial creditors have approved the name of resolution professional RP, resolution professional. And after that, majority of director have given the declaration that this application will be filed in 90 days only. Will be filed in 90 days, and it is not being initiated to defraud anybody. And the declaration will also specify the name of RP to be appointed as per the approval of financial creditors. So there is a form prescribed for declaration, form P6. So there, I would say there are around 15 forms have been prescribed, which have to be followed while doing the process of PPIRP, from P1 to P14, and Form 1 under Pre-Pack Insolvency Resolution Process Rules 2021 for filing the application. So special resolution passed by shareholder means shareholders' approval is also required by through special shareholders' resolution is also required by passing the special resolution. So there are, you have the approval of financial creditors, you have the approval of shareholders, and you have the approval of directors. All when all three will approve this process, then only you can move ahead with this. And the RP who is proposed to be appointed, as mentioned earlier, it will submit a report of Form P8 confirming the all the eligibility criteria, and base resolution plan also confirms all the requirement uh, through this form. So before initiating this process, RP still has to do some duty, and even if PPIRP application rejected, that cost of fees of RP during pre-initiation of PPIRP process will be bear by the corporate debtor. Next, forms where CD meets all above criteria, then corporate applicant file the PPIRP application before adjudicating authority in Form 1 with fee of rupees 15,000. Now, when application is filed, adjudicating authority has only 14 days to either accept this application or reject this application. So, PPIRP, as when it admit the application, PPIRP process commenced. While admitting the application, in the order, adjudicating authority shall declare moratorium, appoint RP, and cause public announcement within 2 days in Form 9. So there's a form for public announcement, which is Form 9. I'm just speaking myself. I hope everyone is getting till now whatever I have explained. Can anybody told me that so far I am going, whatever I have shared here is understandable? Hello? Let's, okay, thank you. So here is my PPT. So while admitting the application, adjudicating authority declare moratorium, do three things: declare moratorium, appoint RP, and cause public announcement within 2 days. Then management of the CD continues with the board of directors and existing management. CD, what corporate debtor, the duty of corporate debtor is to submit the list of claim, preliminary information, and base resolution plan to RP within 2 days. And if the COC does not approve the base resolution plan, the base resolution plan then submitted before the COC by the RP. And if the base resolution plan is not approved by COC, or base resolution plan impairs any claim to operation creditor. Impairs means if it does not provide the full payment for operation creditor, then RP invite further resolution plans from the prospective resolution applicant. So COC will select out of all those resolution plan put up before the COC the best resolution plan, and the approved resolution plan is placed. Uh, the resolution plan has to be approved within 90 days, and then adjudicating authority shall within 30 days of receipt of resolution plan either approve or reject. Then one thing was missing, that COC has to be constituted within 7 days after getting the list of claims from CD and convene the first meeting within 7 days. And RP will prepare information memorandum, preliminary information, and shall file for application for PUFE transaction, if any, within 45 days in uh, Form P7. So, so in this Form P7, if you see the form, it shows that it declares by the RP that either they provide the transaction, or they mention that there is no PUFE transaction. So even if there is no PUFE transaction, this form is to be submitted, filed. So next is total time limit for completion is 120 days, out of which RP shall submit resolution plan within 90 days, and adjudicating authority will approve this plan in 30 days. Where no resolution plan is approved by COC, then RP can file the application for termination of PPIRP by filing form P13. So this was the whole story of PPIRP process. So pre-pack get closed in four possible scenario. One, the approval of resolution plan by COC and adjudicating authority. Next, termination of the pre-pack by adjudicating authority either on completion of time period or on request of COC, or initiation of CIRP by adjudicating authority on request of COC, and initiation of liquidation proceeding by adjudicating authority in exceptional circumstances, uh, which we go through in sections like 54O and 54M. So next, there is a section called section 11A, wherein there is if there which provides for the simultaneous application of PPIRP and CIRP process, how that will be disposed. So they have provided the scenario that if application of PPIRP is filed and after that CIRP application is also filed, then uh, adjudicating authority will decide PPIRP application first. And if CIRP process initiated and PPIRP application is filed after after CIRP application is filed, then PPIRP application is also filed. Then you have to see if it is filed within 14 days of filing the CIRP application, then PPIRP application will be decided by adjudicating authority on priority of CIRP application. If more than 14 days is lapsed, then CIRP application will be decided first, then PPIRP application. So this section 11A talks about this parallel application under CIRP and PPIRP. Next, I have shared a small brief of comparison between CIRP and PPIRP process. First is eligibility. CIRP is applicable on all companies and LPs. PPIRP is applicable for only MSMEs. Minimum amount of default in CIRP is 1 crore, and PPIRP minimum amount of default is 10 lakh. So in case, between 10 lakh to 1 crore, if there is entity which is MSME, then they have only one option, that is PPIRP. But if the default is more than 1 crore, then the minimum threshold under CIRP is 1 crore only. So they have this alternative uh, they have alternative process. They have options, either go to CIRP process or you can go to PPIRP process. Application for initiation in CIRP can be filed either by creditors or corporate debtor itself, financial creditor, operation creditor, or corporate debtor. In PPIRP, only corporate debtor or any person authorized by corporate debtor having the control of financial affair of CD can only file this PPIRP application. Timelines. There is a 330 days timeline prescribed in CIRP, 180 days extended up to 90 days, and maximum 330 days. In PPIRP, only maximum 120 days is uh, given for completing the entire process. Interim resolution professional is appointed In CIRP process, once CIRP process commenced, application is admitted, IRP is appointed. But there is no such concept in PPIRP. Interim resolution professional is not appointed. Only resolution professional is appointed in PPIRP. And resolution professional, uh, RP resolution professional will get appointed on the first COC meeting held on 30th day of insolvency commencement date. Over here, RP will get appointed on the pre-package, will get appointed uh, before pre before this PPIRP process, and do certain duties as prescribed in 54B. Base resolution plan. There is no concept of base resolution plan in CIRB process, but in PPIRB process, it starts with only base resolution plan from its inception itself. Moratorium and public announcement, it is applicable in both the cases. Constitution of COC, there is time period is provided 23 days. There is time period provided 7 days from the commencement of date. First meeting is held within 7 days of constitution of COC. In both the cases, it is same. Preliminary information, there is no concept of preliminary information memorandum in CIRP, but there is this is uh, provided in this PPIRP process, when corporate debtor provide within 2 days this preliminary information memorandum to resolution professional. Then management of the CD. Once this application, CIP application is admitted, the management vested with the interim resolution professional and subsequently transmitted to resolution professional. So resolution professional uh, do manage the affairs of the corporate debtor in CIRP. But in PPIRP process, there is no such case. It remains with the directors, and that's why it is debtor in possession and creditor in control word used in PPIRP. And next is initiation of CIRP. This concept is there in PPIRP, where if COC decide to initiate CIRP rather than going with the PPIRP, then with the 66% of majority, it can file the application for initiating CIRP application, CIRP process. Next, resolution plan. There is equal opportunity to all, but in PPIRP, first of all, board of director provide the base resolution plan. If it is not suitable, then other plans are provided, are invited. So first opportunity is provided to the promoters in PPIRP. Termination when the CIP get terminated, either resolution plan is implemented or approved and implemented, or if not implemented, then the company will go into liquidation. Over here in PPIRP, there is no such case of liquidation. If resolution plan does not get approved, the PPIRP get terminated. But in certain conditions, certain scenario, exceptional scenario, where adjudicating authority uh, finds that there is some gross mismanagement or something like that, and then it can file this, it can order for liquidation. There is only an exceptional scenario. Otherwise, uh, otherwise, the termination of PPIRP ends when either resolution plan get approved, or it just get terminated when not approved. So so these were the broad overview, and let me just share with you the timeline. A timeline of one from the time a PPRP application is admitted. Within 2 days, list of claim and preliminary information based resolution is provided to by corporate data to RP. Then public announcement is uh, uh, announcement is published. But over here, public announcement is not get published in newspaper, just like in CIRB. It just has to be placed at the website of CD and IBBI. Next, within 3 days, appointment of registered valuers. Within 7 days, COC constitution. And from the constitution, within 7 days, first meeting of the COC will be held. Submission of information memorandum based on preliminary information memorandum will be submitted by RP within 14 days. And for inviting resolution plan, this has to be done within 21 days. And in next 15 days for after invitation, resolution plan, the time period will be given for 15 days for submission of the resolution plan. And next, in 30 days, RP has to form an opinion on avoidance transaction. If there is some avoidance transaction, then it has to determine the avoidance transaction in 45 days. And if there is, it has determined the avoidance transaction, then it has to file the application to adjudicating authority for appropriate relief. In T plus 89 days, resolution plans will get evaluated and approved by COC. And in T plus 90 means commencement, after commencement, within 90 days, application to adjudicating authority for approval of the resolution plan or termination of the PPIRP if no resolution is approved. And within 120 days, order for approval of resolution plan or termination of PPIRP will be passed. List of forms under PPIRP. First form is Form 1, application by corporate applicant to initiate PPIRP. So let me just go through all of you with this form. This is very important form to understand. Let me just share with you this form. This Form 1 is prescribed under this pre-pack insolvency resolution process rules. I hope it is visible. Is it visible? Is this rule, PPIP rule is visible to all of you? Is everybody there or just I am speaking to myself? So let's move ahead. So this is the form. And this is the rule, PPIRP rule, which provides that a corporate applicant shall make an application for initiating this PPIB process under Section 54C in Form 1. Along with, it will be accompanied with affidavit and document mentioned in annexure therein in electronic form with a fee of rupees 15,000. And before filing this application under Section 54C, this has to be this copy has to be served to the IBBI. To the IBBI through any mode, by hand, by speed post, electronic, any mode. And this is there is only one rule in PPIRP. This is which is Rule 4, and Form 1. This is the Form 1, which you file to NCLT. Over here, you mention the particulars of corporate applicant. Who is the corporate applicant? What with which authority he is or she is filing this application? Details of corporate debtor date, including date of incorporation, share capital, and detail of C. Over here, you have to attach the proof of MSME like Udyam registration or proof of investment in plant and machinery as annexure. Um, and any authorization letter um, to show that corporate applicant is authorized to initiate on behalf of corporate debtor. Particular of proposed resolution professional, which you get approved through financial creditors with 66% majority. So details of proposed resolution professional is provided here. And then financial details of financial debtor and creditors is provided here along with the proof attached about their debt, and particulars of financial creditor not being related and related both, they provide in different columns. And this affidavit is have to be provided along with this application, where you mentioned that this corporate debtor is eligible under Section 54A, and means all the conditions provided under Section 54A is fulfilled by this applicant, and the resolution professional is also uh, eligible to be appointed, and this application is being filed within the period of 90 days by the as declared by the director. And along with this affidavit and application, there is a list of annexures which they have provided, around 16 annexures. uh, yeah, 16 annexures they have provided to be enclosed with this application. For example, all those documents which you prepare in while doing the process under Section 54A and 54B, all these are to be part of this annexures. Like in case of financial debt, you have to attach the record of default. In case of operational debt, copy of invoice and demand notice, approval of creditors which you took in Form P3. There is a form prescribed, Form P3, for taking approval from financial creditor, and written consent of proposed resolution professional. The form for written consent is provided in Form P1, and declaration of majority of director. There is also a form prescribed under Form P6. This Form P6 has to be annexed, and the special resolution, copy of special resolution has to be annexed, and approval of creditors for filing this application. So there are two approvals which you take from financial creditor before initiation of PPIP process. First is for proposing and proposing IP and approving the name of IP. Second is for initiating, for giving the approval for initiating the PPIP process. So the approval for uh, of creditor in Form P4 for initiating PIP process will be annexed. Report, which I was talking about in Section 54B, IP will submit this report that corporate debtor fulfill all the eligibility criteria under Section 54A, and base resolution plan also fulfill all the criteria. So this report has to be provided by RP in Form P8, and declaration of proof transaction. This proof transaction, whether there are proof transaction or not, that has to be attached in Form P7. affidavit stating that corporate debtor is eligible under Section 29. In that affidavit will be enclosed, and copy of relevant books of account evidencing the default to creditors. So, for default to creditors, there should be some um, uh, relevant books of account that can be annexed over here, and copy of audited financial statement. Audited financial statements of corporate debtor for of last 2 financial years, and for provisional financial statement, unaudited provisional financial statement up to the date of application, uh, not earlier than 14 days of the application, has to also have to be annexed. And a statement of affairs made up to the date not earlier than 14 days from the date. A latest statement of affairs wherein you will mention list of corporate debtors, assets, liabilities, property detail, creditors details, and debts related to connected parties, and guarantee and security, and any other matter relevant to be disclosed here. And relevant extract of any constitutional document or shareholder document agreement that record the authority of corporate applicant. So any authorization letter has to be enclosed. Uh, okay. And if any employee is being who is taking care of financial affairs of the corporate debtor, who is doing this application, then also the authorization letter has to be annexed. Proof that specified application fee has been paid. So there's a fee of 15,000 has to be uh, paid. So the proof also will be annexed here. And there is also a copy of proof that application has been served to the board. So all these 16 annexures has to are required to be annexed with Form 1 for initiating PPIRP application. This is a small, uh, very small rule, IBBI rule, but very important to be read thoroughly. So, uh, next, uh, next is over here. So, one flow chart is there. Just let me take you through this flow chart. When CD makes a default of rupees 10 lakh or more, then CD, if it falls under MSME, as per the Section 7 of MSMED Act, uh, MSMED Act, uh, if it is eligible, yes. If no, then not eligible under Section 54A. If a company is not MSME, then it is not eligible under PPIB. If eligible, then yes, it has to see other conditions, like it is not undergoing any PPIRP or CIRP process during last 3 years, and it has not undergone any CI is not undergoing any CIP process or liquidation order, ineligible under 29. If yes, then not eligible to move ahead. And then if no, then CD issue notice of not less than 5 days. 5 days notice for convening the meeting of financial creditors for getting the approval for initiating the CIRP process. So, CD issuer not less than 5 days. This period can be reduced up to 4 hours if approved by all the creditors. But if there is no such approval, then at least 5 days notice has to be given to financial creditors for a meeting. Um, and this should be financial creditors should be unrelated financial creditors. And before for getting the approval, you have to place before the financial creditors all these things: list of creditors in Form P2, copy of declaration in Form P6, declaration of directors, which Earlier we were talking about declaration which given by the director. This is the same declaration in Form 6 P6, special resolution and base resolution plan. So after if uh, you when you have placed this all these things before the financial creditor, then financial creditors with 66% of in value of financial debt, if they approve, then you can move ahead. If they not, then PPIP process ceases over there only. If they approve, then CD prepare the full set of application in Form 1 with annexure towards the same to the board through registered post or by hand or any mode. And then has the CD filed the application with adjudicating authority within after Form 1 has been filed. Uh, if CD filed the application with adjudicating authority within 90 days of declaration in Form 1, proof that a copy of application has been served to board. If yes, adjudicating authority shall within 14 days of receipt of the application pass the order, either admit or reject. If admit, PIP process commence. If rejected, RP's PRP role ceases, and he is eligible only for pre-PRP fees that will be paid by CD. So this was the flow chart, and this flow chart was provided by IBBI at their some brochure. And they pre-admission stage we have already discussed. Over here they said ki if adjudicating authority admit the application, RP will constitute COC within 7 days. The CD either admit base resolution plan. If they admit, then base resolution plan is disclosed. An alternate plan, if BRP impairs operation creditor, impairs operation creditor means if they are not providing the payment for operation creditor, then this alternate plans will be invited and the best alternate plan is selected. If BRP does not impair operation creditor, COC approve the base resolution plan it only. It will not invite further plans. If it approves base resolution plan, then plan will be submitted to adjudicating authority within 90 days. If it does not approve the BRP process plan, then alternate plan will be invited. If alternate plans are invited, there are three options: basic, alternate plan is not significantly better than this BRP, base resolution plan. Yeah, it is better than BRP, or no plan is received. Teen scenario can happen only. If it is not significantly better than BRP, then uh, these two can challenge each other by the process of Swiss challenge provided in this in the pre-pack regulations. And if best alternate plan is significantly better than BRP, then COC may approve that plan. If no plan is received, then COC may approve BRP. If it approve, then plan will be submitted to adjudicating authority. If not, then um, pre-pack closes without resolution, or if COC does not approve this alternate resolution plan, then also. And if after this Swiss challenge, COC approve that winning plan, then plan will be submitted to adjudicating authority. If does not, then the pre-pack will close without resolution. So this was the typical process flow which was provided by IBBI at their website. So over here, I am showing the consideration and approval of resolution plan. So corporate debtor, what happens is First of all, corporate debtor. Over here, the priority is given to the corporate debtor itself to submit their base resolution plan within 2 days. Then RP represent the base resolution plan to COC. COC give the opportunity to CD to revise the base resolution plan if it is required, or invite prospective resolution applicant. RP ensure that base resolution plan and resolution plan conform to the provision of the code. COC then approve the base resolution plan for submission to NCLT if it does not impair any claim owed by CD to the operation director. If COC does not approve the base resolution plan, then it will invite prospective resolution applicant to submit resolution plan and to complete the base resolution plan. Their Swiss challenge will start. RP will provide prospective resolution plan with the basis for evaluation. RP will provide the evaluation criteria and relevant information relating to information memorandum to the resolution applicant into the COC. And then RP place all the resolution plan which confirm the provision of the code before the COC for its approval. COC shall evaluate the resolution plan and select the best alternate resolution plan. COC shall approve the best resolution plan which may include base resolution plan by 66% voting share. The approved resolution plan is submitted to NCLT by RP, and in case no resolution plan is approved by the committee, RP shall file an application with NCLT for termination. So this was the whole picture of consideration and approval of resolution plan. So till now I have covered the overview only of pre-pack. Let me show you the current standing as well. See, so far, as per the latest newsletter of IBBI issued in the last quarter, there are approx 16 applications only received for PPIRP. The first application was GCCL, Infrastructure and Project Limited, which was the first case of PPIRP which got approved. And out of 16, 10 applications have been approved so far. These are the 10 applications of PPIRP, Anti-International, Amrit India, Sudal Industry, Shri Rajasthan, Mudra, and this Garodia. So these are the 10 applications. One application, Loon Land Developers Private Limited, it was admitted, then withdrawn. And then there are still around 5 applications which are still pending before the NCLT. One application was withdrawn prior to the admission, Krish Realtek, and one application was rejected by NCLT because it favors CIRP over NCLT favors CIRP over PPIRP. So from 2021 till 2026, in this 5 years, only these applications are filed and only 10 applications are approved. So what are the causes? What are the reasons? First of all, reason is lack of knowledge. MSMEs do not have the knowledge about this PPIRP process. They, maximum MSME, not all MSMEs, they generally prefer this one-time settlement process prescribed by RBI, which is similar to the out-of-court settlement, wherein both get agreed with certain conditions and then settle uh, their default. And in that, no NCLT intervention. So still from PPIRP, OTS is preferred over PPIRP. And since promoters who, if CD has defaulted, then still the management is being vested with the promoter. That is also the limitation creditors perspective, creditors also do not prefer this PPIRP. They prefer the SARFACE or OTS because they don't believe in resolution. They believe in recovery of their money. Or there are procedural delays. If you see what I have shared with you, this current standing of applications, all applications which are got approved have taken the time of more than 1 year or 2 year. But in this PPI process, maximum time limit is 120 prescribed, which is not followed. So and under PPIRP process, when all lacuna secured, lenders need to share their secured interest with other lenders and also face haircut on their dues lent. So this is not the case of SALFACE where they don't need to share their secured interest with other creditors. So these are the limitations because of which PPIRP could not be uh, used or utilized as it was intended. And next is how to is encourage more PPIRP applications. First of all, more MSMEs should be get aware about this process. Perspective change should be required, and some more changes in terms of legal framework related to connected people and other uh, lacunas has to be uh, take care of. So this was a small brief about the entire PPIRB process, which I am assuming I have elaborated in detail. If there is any confusion or anything which anybody want to know uh, till so far, which whatever we have covered, then you can share with me. Otherwise, I will go with the legal framework in detail. So should I go with uh, my PPT, or I think there is no issue or questions from any participant right now? Uh, can you tell me if I am getting, means if whatever I am I have just spoken has been uh, cleared uh, by you, or means is can anybody tell me that it was clear till now? Okay, so let's go with uh, each section one by one. There are, as I mentioned, there are 16 sections which we have to cover in PPIRP under Chapter 13, it's 3A, and 16 forms which you have to uh, follow, and PPIRP rules and PPIRP regulations along with it. So, with each section, I will share with you the Bear Act as well. Section 54A. Let me share with you the Bear Act also. I like to read law from Bear Act. It only give you more clarity. So let me just share with you that. This is IBC Bear Act. This is chapter 3, repack insolvency resolution process. I hope it is visible to all. Uh, Section 54A. As I mentioned, and I have spoken brief about this section. Section 54A talks about corporate debtors eligible for prepack insolvency resolution process. Section 54A subsection 1 says an application that is form 1 under prepack insolvency resolution rules. IBBI rules. An application for initiating prepack may be made in respect of corporate debtor. Corporate debtor means not other than corporate entity will be covered. Corporate debtor classified as MSM, micro, small, or medium enterprises under subsection 7, under subsection 1 of section 7 of MSMED Act 2006. Means first and the foremost uh, condition is this application can be filed by MSME only. Then subsection 2 says without prejudice to subsection 1, means this condition will remain there. Without this, the following condition has to be fulfilled. An application for initiating PPIRP may be made in respect of a corporate debtor who commit a default referred to in section 4. So in section 4, there is, let me show you section 4 also. This application of this part. Which part? CIRP part. And in this part, part 2, chapter 3A has been introduced. And in this second proviso, they mention that central government may by notification specify such minimum amount of default of higher value which shall not be more than 1 crore for matters relating to prepack. So section 4 talks about minimum amount of default for triggering prepack insolvency resolution process. So minimum amount of default over there in section 4 has not been prescribed. Separately, central government has notified this amount as 10 lakh with effect from 4th April 2021. So this was section 4, and the so if first criteria is fulfilled, that a corporate debtor is MSN, then if the minimum amount of default is 10 lakh under section 4, then subject to the following condition, an application can be made. So what are these conditions? First is it has not undergone prepackaged insolvency, PPIP process or CIP process, which in last 3 years, it has not undergone PPIP or CIP process. Means there should be some cooling period of 3 years between the two processes. At present, it is not going any CIP process. If it is already going CIP process, then this will not be used. This cannot be used. And no order of liquidation under Section 33 was passed. D. It is eligible to submit resolution plan under Section 29. And Section corporate debtor is eligible under Section 29. There are certain conditions that has to be fulfilled. Eligibility criteria under Section 29, which needs to be fulfilled. Then clause E says financial creditors which are unrelated, not related to the corporate debtor, representing such number in such manner as they is specified. That number is specified under prepackaged insolvency regulation, IBBI, BPIP regulation 2021, that financial creditor, unrelated financial creditor, have to propose the name of the IP with 10% uh, with 10% of the financial creditor with 10% value of the financial debt have to propose the name of insolvency professionals, and that name of profession IB professional has to be approved by financial creditors with uh, at least 66% in value of the financial debtor total debtor. So this you have to propose the name of IP, and if there is no financial creditor, corporate debtor does not have the financial creditor, or financial creditor as related party, then again regulation will be followed, wherein it is mentioned that operational creditor with top 10 operation creditors and one workman, representative of workman, and one representative of employee will constitute COC. The majority of directors, next condition is majority of director has to give the declaration in the form is prescribed under the regulation again. This is Form 6 of the regulation. I think I have not gone all of you through the forms part. I will go you through at the end of the this sections forms. I will take you through the forms also. There's a form prescribed for declaration of by the directors. What they will declare? They will declare three things. First, that this PPIP process will get initiated. An application regarding this PPIP process will be filed within 90 days of this declaration. Declaration के 90 days के अंदर ही एक एप्लीकेशन PPIRP की एप्लीकेशन फाइल की जाएगी. नेक्स्ट, PPIRP प्रोसेस से थ्रू दिस प्रोसेस यू आर नॉट डिफ्रॉडिंग anybody. Third, you are proposing IP, name of IP, which is approved by financial creditors. So directors will give this declaration, these three declarations. And then third, you have to take the approval from shareholders also by passing special resolution in case a company is a corporate entity, and in case company is a firm or LLP, then 3/4 of the total number of partners will give the approval for initiating this process. Subsection 3 talks about once you have taken the special resolution, you have this declaration, you have the name of the this IP, name of the IP who is proposed to be RP for this process. Then you have to go for financial creditors for again taking approval for this, for initiating PPIRP process. Means you are going before the financial creditor for two times. One is when you are taking the proposal of name of the IP from at least 10% of the financial creditors and with the approval of 66% of financial creditors. And after taking the approval name and special resolution and declaration, then again you are convening the meeting by giving not less than 5 days notice to financial creditor, and this you take approval from financial creditors for this thing. But you would say for this initiating this process. So before taking the approval, you have to provide all these things to the all these three things to the financial creditors. First is declaration, director's declaration, which three declarations they mentioned, which we spoke earlier about. Special resolution, we have the shareholders approval also. Then the base resolution plan. You director themselves prepare a base resolution plan and then propose to the directors that this is we are expecting to resolve this default. So we are putting towards you if you want to approve this base resolution plan. When you get the 66% approval from the financial creditors, then next step is section 54B. In section 54B, there is a duties of insolvency professional prescribed before initiation of pre-insolvency resolution process. So, under section 54B, the IP who is proposed to be appointed as RP have to give the report that all the eligibility criteria and conditions prescribed under section 54A and all the criterias for base resolution plan have been fulfilled, uh, and along with that, um, so this report has to be provided by the insolvency professional. And in case ins if this IP continues after getting the PPIP application admitted, if continues, then that will be part of the cost of insolvency resolution process. But if the application get rejected, then the fee of insolvency professional shall be borne by the corporate debtor. So this is whole talks about section 54B, duties of IP. Then the most important section comes, which is 54C. So 54C, from 54C, the insolvency PPRP process gets start. Before that, we are doing pre-arrangement for starting the process between the creditors, shareholders, and directors. So in section 54C, it talks about application to initiate PPIRP. And we have gone through with the application format, form 1, just now. Under this provision, it says corporate debtor, if meets the requirement under section 54A, then an application can be filed for initiating PPIRP with the adjudicating authority. This application shall be filed in such form. Which form? Form 1, containing such particular, which we have discussed, accompanying with such fee. How much fee? 15,000 rupees, which we have discussed in the rules. So this application has to be filed accordingly in this form with this fees and with the particulars which is prescribed. The corporate applicant shall, along with the application, application के साथ, with application we have already discussed all the annexures which we have prepared during section 54A and 54B process. We attach all those with the application, declaration, special resolution, approval of financial creditor, name of sorry, name and written consent. IP, the name whose name is being proposed and approval, you have to take his written consent also, na? So this written consent has to be in the prescribed form, which is form P1. That has to be uh, attached with this application form, and a declaration about the buffet transaction that has to be attached. Information relating to books of account. Here, books of account means relevant books of account related to the default of corporate debtor and such other documents. In such other document, rules prescribe that, regulations prescribe that you have to annex the audited financial statement of last 2 years, and then provisional uh, financial statement, uh, provisional financial statement uh, till the date of application, which should not be earlier than 14 days from the application, and base resolution plan. These has to be, these are prescribed under the regulations. And this is after filing this application, adjudicating authority under subsection 4 has 14 days time to um, either admit the application or reject the application. If an application is complete, it will admit the application. If an application is not complete, it will reject, and it will give 7 days time to rectify the incomplete details or defect in the application. So under subsection 5, it says the moment it is admitted, the pre-packaged insolvency resolution process gets started, get commenced. So this is section 54C. So we have covered so far 3 sections, section 54A, 54B, and 54C, out of 16 sections. So 13 sections are remaining. 54D is a very small, short section which specify about the time limit for completion of prepackaged insolvency resolutions. It says the total time limit is 120 days from the date of commencement of prepackaged insolvency resolution process, and without prejudice to the subsection 1. Means this is the overall limit. Without prejudice this, the RP shall submit the resolution plan as approved by COC to the adjudicating authority within a period of 90 days. So total overall limit is 120 days, but RP on COC has time to approve the resolution plan. They have the time limit of 90 days only. And the rest time is for adjudicating authority to approve the resolution plan within next 30 days. So there is total 120 days, and there is no extension prescribed or provided under section 54D. Section 54E. Section 54E talks about declaration of moratorium and public announcement during the pre-packaged insolvency resolution process. So declaration of moratorium. So once the admission order is passed by the NCLT, it declares the moratorium. Similarly, it does in the CIRP case, it does in the similar order. It passed in this PPIRP also. It declared moratorium once it admit the application. And then appoint RP, which is named in the application if there is no disciplinary action proceeding is pending against him. If there is any disciplinary proceeding pending against him, then the name will be suggested, recommended by the board, and that person will be appointed as resolution professional. And then cause public announcement of initiating PPIRP process to be made by RP. In such form is prescribed in the manner means they have provided the manner um, to publish this at the IBBI website or at the debtors website, not on newspaper. So these three orders will be issued by NCLT while passing the admission order. And the order of moratorium shall have the effect from the date of such order till the date of which prepackaged insolvency resolution period comes to end. The moratorium will continue till the process ends. This was section 54E. Then 54F. Now, since PPRP process started, now the RP will have certain duties and powers to conduct the PPIRP. The first duty is that it will conduct the PPIRP process during this period. Second, it has to, during that, while conducting the PPIRP, it has certain duties like confirm list of claims. List of claim who will provide? Corporate debtor will provide. So then it will confirm the list of claims, inform the creditors regarding their claims, maintain updated list of claims, monitor management of affairs of the corporate debtor, inform the COC in the event of breach of any of the obligation of the board of director partners under this provision, constitute COC. COC has to be constituted within 7 days. Constitute COC and convene and attend all its meeting. RP will be the chairperson of all the COC meeting and prepare information memorandum based on preliminary information which was provided by uh, corporate debtor and file application for avoidance transactions and such other duties as may be specified. Subsection 3 talks about powers. What all are the powers of RP during PPIP process? It can access all books of account, records, information, electronic records available with the corporate data, available with the government authority, statutory authority. Attend all meeting, be it shareholders meeting, board of directors meeting, COC meetings, all meetings of the corporate debtor, appoint any professional. He can appoint or she can appoint any professional and collect all information related to asset, finances, and operations to determine the proof transactions. And from the date of appointment, financial institutions, banks will furnish all information to the RP as and when required. And all personnel and staff of the corporate director, promoter, any other persons associated with the management will extend all assistance or cooperation to the RP. The fee of the RP and expenses incurred by him will form part of the PPIRP cost, and COC may impose the limit. COC will fix the fees and may impose the limit. And next has section 54G, list of claims and preliminary information memorandum. Who will provide list of claims and preliminary information memorandum? List of claim and preliminary information memorandum is provided by the corporate debtor. Corporate debtor within 2 days of the commencement of the PPIRP. There is a form prescribed for list of claim for which is form P2 and preliminary information. The preliminary information as per section 30 or you will the same similar provisions will be applicable here also of CIRP. And where any person has sustained any loss or damage or consequences of omission of any material information mentioned in the preliminary information, this then the person, promoter, director, or who has authorized the submission of list of claim or preliminary information, that person will be liable to pay the compensation to every person who has sustained the loss or damage. And if this claim or preliminary information was submitted without his knowledge or consent, then no such compensation has to be paid. And Section 54H, it talks about management of affairs of the corporate data. We already discussed the management continues, existing management continue to vest with the board of directors. Board of directors shall make every endeavor to protect and preserve the value of the property and manage its operation as a going concern. And promoters members, personnel shall exercise and discharge their contractual subject to the provision of this chapter. So main theme of this section 54H is that the existing management will continue uh, the affairs of the corporate debtor. Next, 54I. It talks about COC, Committee of Creditors. So it says RP shall within 7 days of commencement of PPI-RP constitute a COC based on the list of claims confirmed under Section 54F. So first duty of RP after getting the list of claims from the CD within 2 days, uh, from that within 7 days of commencement, RP has to uh, constitute COC, and the first meeting has to be convened within 7 days of the constitution. And if the list get updated, composition gets changed, then the past decision of COC will not get altered, will not get affected. 54G, vesting management of corporate debtor uh, with RP, resolution professional. Here, COC has the power if it says that at any time during the PPIM process, if with the voting of 66% of majority, resolves to vest the management of the corporate debtor with the RP, the RP shall make an application. RP shall make an application for this purpose. The in the form is P14. In that form, an application will be moved to to shift the management of the corporate debtor to the RP. Then if application is received under this subsection, the and AOA is of the opinion that PPRP has been conducted fraudulently or there is a gross mismanagement, then it shall pass the order to pass the management to the RP. Then the provisions, some of the CIB provisions will be applicable in case RP takes over. And then another important section 54K, consideration and approval of resolution plan. It says corporate debtor shall submit the base resolution plan. So first priority is given to the corporate debtor to submit the resolution plan within 2 days of PPIRP commencement, and the RP shall present the same to the COC. The COC may provide corporate debtor an opportunity to revise the plan or invite prospective resolution application. If RP and resolution plan, base resolution plan are submitted, then RP will ensure that they are fulfilling all the criteria, and COC either may approve base resolution plan if it does not impair any claim, and where the COC does not approve the base resolution plan or base resolution plan impairs any claim of operation character, then it will invite the prospective resolution applicant. The resolution applicant submitting resolution plan shall fulfill all the criteria Hmm. Then, what is the duty when there is more than one resolution plan? Then there has to be some evaluation criteria of resolution plan. That evaluation criteria will be provided by RP, which will be approved by COC, and the relevant in the resolution plan is professional. Then submit, present the COC for its evaluation. All this resolution plan, COC shall evaluate as per the evaluation criteria and select one resolution plan. If it selects and approve the resolution plan, and if the base resolution plan is significant, the uh, resolution plan, which was alternate resolution plan, you can say, is significantly better than base resolution plan, then that resolution plan may be selected. If uh, is not resolution plan is not considered for approval and does not fulfill the criteria, then it will compete with the best base resolution plan. There is certain process prescribed under the PPIRP regulation. As per that, they both have to compete with each other and uh, get the score. Um, After all this process, resolution plan selected for approval may be approved by COC, and where it is approved, it shall file an application. Uh, if it is not approved, if resolution plan after all that process not get approved by COC, then RP will move to termination of PPIRP. So if in this PPIRP process, if resolution plan does not get approval, there is no liquidation of that MSME. There is a termination of PPIRP process. Now it will go back to the point zero and nothing is going to implement. The PPIP process will get terminated. And uh, once it get approval of 66% of COC, if any plan gets approval of 66% of financial creditors, then it will be submitted before the adjudicating authority. So yeah, over here there is explanation about that claim shall be considered impaired. When the claim shall be considered as impaired, where the resolution plan does not provide for the full payment of confirmed claim as per updated list of resolution plan, does list of claims maintained by RP. Next 54L, it talks about adjudicating authorities power to approve the resolution plan. 54L says if COC has approved the resolution plan, then it adjudicating authority shall, within 30 days of the receipt of resolution plan, order approve the resolution plan. Before passing such order, it will satisfy that resolution plan has provisions of its effective implementation. So, subsection 2 provides that it shall have effect under section 31. 31, there are certain criteria for resolution plan, that all those criteria will be applicable for the resolution plan under this provision also. And where the adjudicating authority is satisfied that the resolution plan does not conform to the requirement referred to in subsection 1, it may within 30 days of the receipt of such resolution plan by order reject the resolution plan. So um, not subsection 4 talks about um, where the adjudicating authority has passed an order under section 54J and resolution plan approved by COC. uh, does not result in change in management, control of CD to a person who was not a promoter, the adjudicating authority shall reject such plan, terminate the process, declare PPRP shall be included as liquidation cost for the purpose of liquidation. So, in this exceptional case, liquidation order will be passed. 54M, it talks about any appeal against an order approving the resolution plan under approve the order which is passed under section 54L can get against that order, and appeal can be filed on the ground under section 61 subsection 3. Under section 61 subsection 3, there are certain criteria. Uh, there are certain criteria prescribed which talks about this grounds. Let me show you that. See, let me share this with you. See, these are the grounds under section 61 under which an appeal against the order of NCLT can be passed. These grounds are the approved resolution plan is in contravention of any provision. There is a material irregularity in exercise of the powers by the resolution professional during the CIP process. The IRP cost have not been provided for repayment in priority of all other debts, or the resolution plan does not comply with with any other criteria specified by the board, and debt owed to operation creditor of the CD have not been provided for in resolution plan in the manner specified by the board. So on these grounds, an appeal against the CIRP order can be filed. So NCLT order can be filed. So this was 54M. And now there is only 3 sections left out of 16 sections. Now we have come to the section 54N, which talks about termination of PPIRP process. So when will this PPIRP process get terminated? So either um, it will be terminated when no resolution process no resolution plan get approved, or if or it will be terminated when resolution plan is approved. In both the situation. Um, so this over here at any time means this is provided under subsection 1, and subsection 2 says where the RP at any time before after PPIRP but before approval of the plan intimate adjudicating authority of the decision of COC approved by not less than 66% to terminate PPIRP. Means apart from all the above situation, if voluntarily wants to go with termination of PPIRP process before approval of resolution plan by COC, if COC is resolved to terminate the PPIRP, then also PPIRP process can be terminated. In that case, if PPIP process gets terminated, the CD shall bear the cost of prepackaged insolvency resolution process. And where this PPIP process get terminated by the adjudicating authority for liquidation, uh, uh, get terminated in case of 54J. 54J talks about mismanagement and gross mismanagement uh, scenario where it can pass liquidation order. And in that scenario, also liquidation or when liquidation order pass, this process will get terminated, and this PPIP cost shall be included in the liquidation cost of liquidation process of CD. So this was section 54 and now initiation of CIRP. See, generally, um, the process will get terminate over here only when RP resolution plan got approved, and if not approved or liquidation order pass, etc., etc. But if COC thinks that no, PPRP is not appropriate for this CD, we have to go for CIRP process, then it can do so by again with the 66% of vote majority approval and filing the application before the initiate this NCLT to accept this application as CIRP. And if all the criteria of chapter 2 get fulfilled for initiating CIRP process, then adjudicating authority within 30 days of such intimation either terminate do three things. First, terminate PPIP process. Second, initiate CIRP process. From the date of that order, the CIRP process will commence. Appoint RP. That RP which was doing PPIP will continue as IRP if continue will as IRP, and declare PPIP cost shall be included in the CIRP cost. So all this order will be passed by NCLT if it gets the application of CIRP and all the provisions of chapter 2 are fulfilled to admit this application. If RP fails to provide the written consent, means over here before the same RP will continue as IRP by providing the written consent. If it does not provide the written consent, then adjudicating authority shall appoint some other IRP at the recommendation of the board as the IRP for this new process of CIRP. Okay, then this order will be considered as admission of CIRP process. Last section we have reached application of provision of chapter 2, chapter 3, chapter 6, chapter 7 of this chapter. So there are certain provision chapters or sections which will be applicable to PPIRP also in terms of information memorandum, in terms of resolution plan, in terms of COC. In all those things will be applicable to PPIRP process as well. So with this, we have gone through with all these 16 sections. Now let me go through with you that forms. I think I have not gone through with this forms prescribed under this provision. I hope it is visible. Let So there are 14, no, 15 forms under PPIRP process. First form we have already discussed, form 1 for application to initiate PPIRP. Then form P1, this is written consent by IP to act as RP. This you take at the time of section 54A when you propose the name of IP, and that written consent has to be annexed with form 1. And then form P2, it talks about list of creditors to be provided by the corporate debtor. So there's a format of list of creditor where the amount, the percentage, and the name and details of the creditors is provided. That format is in form P2. Form P3. Form P3 here, apart from taking written consent, you have to get the approval for the terms of appointment of RP, also including his fees as well. So this is form P3, wherein you get the approval of terms of appointment by the financial creditors, unrelated financial creditors. P4. P4 is approval for filing application to initiate PPIRP by uh, unrelated financial creditors. And P5 is written consent by IP to act as authorized representative. So while preparing the list of claims, I, IP RP will identify the class of creditors, and those for each class of creditor, it will have to appoint one authorized representative. That authorized representative, it will propose the three names of IPs for becoming the authorized representative of each class, and that will be approved by the financial creditors. So that authorized representative who will be the IP for each class of creditors, that person will have to provide his written consent in P5. Then declaration of directors, majority of directors, which we initially at the initiation of this process, board of director have to give. This is form P6 under section 54A. And then a declaration regarding existence of avoidance transaction, PUFE transactions. So all those PUFE transaction, whether there is PUFE transaction, whether there is no PUFE transaction, be it whether there are such transaction or not, this uh, declaration has to be given. P8 is report of format of report by the IP who is proposed to be appointed as RP, and who has to, before initiating this process, PPIB process, has to give this report declaring that all the requirement under 54A and 54A are fulfilled. And base resolution plan is also as per the requirement. And then P9 is a format of public announcement by the RP. And then list of claims, P10 by CD, and P11 is invitation for resolution plan. P12 is compliance certificate. At the time of filing the application, you have to after this process of PPIRP, at the time of filing the application for resolution, approval of resolution plan approved by COC, you have to attach this P12 also, compliance certificate by RP, that all the provisions of 54A to 54P are complied with. And then if any application for termination of PPI-RP has to be moved by RP with the approval of COC with 66% majority. Then P13 application for the format of P13 will be filed. And last application is for vesting the management of CD with RP in exceptional circumstances where it seems that there is a mismanagement or gross mismanagement, something, then P14 will be filed. So these all are the details of forms that you need to follow while doing this process. So I would like to ask if anybody is having any query or anything anybody want to discuss on this particular topic. They can share their views or let me know if the entire PPT uh, was helpful for you in certain way or not. Anybody would like to share any query? If anybody want to share any question, want to ask any question or anything related to PPIRP, or anybody want to ask anything related to this entire process which I have elaborated. Are you all there or not? I think I'm just giving my presentation to myself only. No one is responding anything. So I am done with all the provisions. Only one thing is left, that is regulation, which I have covered while presenting this presentation. But still, I think I should share the same with you. Visa prepack, IBBI prepack insolvency uh, resolution process regulations 2021 got effective from 4th April 2020, 9th April 2021. Over here, whatever is I have missed so far, I would like to discuss first general provision which talks about meeting and communication. It can be by physical mode, it can be by electronic mode, it can be the combination of both. Essential supply the same which is given under the CIRP process, nothing new. PPRP cost will include fee payable to authorized representative who will be the IP appointed to be as authorized representative, and out of pocket expenses of authorized representative. Eligibility criteria for resolution professional. Eligibility criteria over here, first of all, you have to take the consent for inform P1, and that IP uh, that IP shall be eligible to be appointed as an IRP or RP as a case. Uh, It says that IP shall be eligible to be appointed as an IRP or RP as the case may be if he or all of the partner are independent. So whoever IP you will be appointed, that has to be independent. Independent means they have provided the explanation. Independent means he is eligible under to be appointed as independent director under Section 149 of Companies Act. So whatever criteria is prescribed under Section 149 of Companies Act, that has to be fulfilled by that IP. It should not be related to a corporate debtor. It should not be employee or proprietor partner or related to auditor firm or consulting firm. And RP, who is director or partner of IPE, um, shall be ineligible to continue as RP in the process if the IPE represent any stakeholder. Next, fee. Fee of RP. If in case PPRP application gets rejected, yet the corporate debtor does not file the application within the timeline provided within 90 days, then this RP fee shall be borne by the corporate debtor. And it also provides that the corporate debtor shall maintain a separate bank account, which will be used by resolution professional for carrying its activities to meet his expenses and fees. Access to the books, definitely the RP will have access to the books of account and other documents mm, held with members, directors, professionals, contractuals, registry records, etc. Appointment of professional RP may appoint, but that person again has to be in, uh, independent. It should not be related. It should not be related to the auditor. It should not be related to the relative of RP. He should not be the relative to the RP. He should not be registered with it. Registered with regulator of the profession concerned. So all these criteria has to be fulfilled. Approval by financial creditors. So applicant will convene the meeting of financial creditors under Section 54A. So it talks, this regulation provides for the meetings under Section 54A, wherein notice will be served to financial creditor by giving at least 5 days, uh, by giving 5 days time. At least 5 days notice has to be given. And notice shall indicate date, time, venue, and list of creditors, which is in the format of Form P2. And financial creditor who are not related party and less than who have not less than 10% value will propose the name of IP under Section 54A. Approval of term of appointment shall be given in Form P3. Term of appointment will include three things: fee payable to him for performing the duty, fee payable to him for and expenses incurred by him, and fee payable to him and the expenses incurred by him in case of management is vested to him. Management of corporate debt is vested to him. Approval of filing the application, that 66% financial creditors approval will be given in Form P4, where there is no financial debt or all are related parties. Then operation creditors meeting will be convened as COC. Choice of authorized representative. If there are any class on examination of list of creditors in Form 2, P2 provided by the corporate debtor, if there as if RP a certain class of creditor, it will uh, appoint IP as the authorized representative for the uh, class of creditor in Form P5. And sorry. Um, yeah, at least three inform IPs will be proposed by RP to be appointed as authorized representative of class of creditors. Out of them, they will select the IP, who is a choice of highest number of creditors, and inform the name of IP with his consent in Form P5 to the applicant. Declaration, there are two declaration. One is direct majority directors declaration 54A, and the another is declaration related to this avoidance transaction under 54C. So these format have been provided, Form P6 and Form P7. Report by resolution professional. Again, the form has been provided, Form P8. Information to be furnished by the applicant. So these, apart from all those documents which they prepare under 54A and 54B, that will be enclosed in the application under section 54C. Three documents additionally will be attached. One is audited financial statement for the last two financial year, and second is provisional financial statement for the current financial year made up to the date of declaration. Form P5, this is the consent of authorized representative. So these three uh, information will also be furnished by the applicant. Public announcement. There is a form prescribed for public announcement, which is Form P9. This has to be made within 2 days. This has to be made within 2 days of commencement of the process. It will be served to all directors and to information utilities, and it will be published on the website if any of the corporate debtor and the board. That means it will not get widely published through newspaper. It will be published only on the website of the corporate debtor. This might be another reason of limitation of PPIRP, that there is this invitation, public announcement is not uh, published in newspapers like we do in CIRB process. Next, list of claims. List of claims, we CD itself submit. There are 51 regulations. We have covered 20 and so far. So let's cover it. List of claims. List of claims P10, which if this is the format P10, and corporate debtor has the responsibility to submit it before the RP within 2 days. And RP shall inform based on the records and other relevant material available on record. RP will confirm the details of P10, and then resolution professional shall inform every creditor regarding its claim as confirmed by him. A creditor, then each creditor he will inform about their claim, and the creditor may submit their objection if they want to with the proof within 7 days, and RP may call extra evidence, and then RP may consider objections and modify the claim accordingly. Then update its claim, shall maintain again the list of updated claims. This list of claim will be available for inspection by creditors, by members, by directors, guarantors. It will be displayed on the website. It will be filed with board and present to the COC meetings. Determination of claim, these are simple things. COC in the class. Committee with only operation character, where there is no financial debt or financial creditor are related party. Then COC will consist of operation creditors. not related to the corporate director, and these operation characters shall be 10 largest operation character by value. And if there are less than 10 operation character, then the committee shall include all such operation character. And there will be one representative from the workman, and there will be one representative from the employee. And member of committee, uh, member of committee shall have the voting rights in proportion to the debt they are holding. A committee formed in regulation this and this, its members shall have the same right, power, and duties. Change in committee. If there is any change in committee due to the updation of the list of claims, then that has to be intimated within 2 days to all the members of COC. Regulation 26. Meeting of committee that can be convened anytime as per RBI, as per RP, resolution professional, but it will be mandatorily be convened if there is a requisition from the COC member holding 33% of voting share. And then notice of meeting. Over here, for the COC meeting, 3 days notice is provided. At the pre PPIRP stage, um, there was a time given for 5 days notice period. Over here, there is a time period given for 3 days notice period. So there is a difference in pre and post PPIRP process. Committee may reduce this period to such period not less than 24 hours. In case there are authorized representative, then it cannot be less than 48 hours. Service of notice is a small general things. Content of notice, same venue, time, वगैरह not to mention. Quorum. How many members will be considered the quorum? Over here, they have mentioned 33%. 33% members having voting share of 33%, either in person or video conferencing or any other audiovisual mode, shall correct the COC meeting. If there is less than the quorum, less than 33%, then the meeting will stand automatically adjourned to the same time place on the next day. And in case that John meeting, in that John meeting also, whoever are attending the meeting will correct the meeting or will complete the quorum. Conduct of the meeting, RP shall act as the chairperson of the meeting. It will roll call the members. It will inform all the members. Sorry. Minutes will be made within 24 hours of the meeting. So in case of authorized IP being the authorized representative, there's a fee prescribed for each meeting. If they are representing 10 to 100 100 characters in class, then IP will get 15,000 rupees per meeting. If 101, more than 101 to 1,000 characters are in class, then 20,000 uh, rupees per meeting. If more than 1,000 characters are being represented by IP, then 25,000 per meeting. The authorized representative will circulate the agenda to each characters on the class and take the views. Our registered value will also get appointed. Fair value and liquidation value. There is a manner prescribed. That RP will appoint two set of registered values. This is the new amendment on 25th Feb which came, and then they are providing that not only just two registered valuers, they will appoint two sets of registered valuers, and each set of registered value will contain two registered valuers. One will represent each class, then the other one will be the coordinating valuer. So there is some manner has been provided for valuation by registered valuer. Information memorandum, all the provision related to information memorandum applicable under a CIP process will be applicable here also. This has to be prepared by RP, finalize and submit to the member of COC within 14 days of commencement. Differential in other transaction. Over here, they have provided the 3 time limits. On or before the 30th day, T plus 30. Pre-commencement insolvency commencement date. From that day to within 30 days, they have to form an opinion. RP has to form an opinion. And then within 45 days, it has to determine the transaction. And no, it has to form the opinion where is of the opinion that this transactions are being done, yeah, have been done. Then in uh, next 60th day, till 60th day, it will determine the exact transactions which will be covered under proof of transaction. Then scoring and improvement of resolution plan. There are scorings and improvement where you can say the Swiss challenge process has been prescribed, wherein significantly better resolution plan will get the higher score. And if the new resolution plan is not significantly better, then it will compete with the base resolution plan by getting more score and improvising that resolution plan by tick size. So next is invitation for resolution plan. Resolution plan, resolution professional shall submit invitation for resolution plan in form P11 within 21 days. It will publish in the website of CD or board of director. And it will mention the last date will be 15 days from the date of issue of notice. And it will provide the all steps. And 44 talks about resolution plan, which shall include maximization of value of asset, including transfer of all or part of the asset, etc. So all these sale of all or part of the asset, restructuring of the corporate debt, substantial acquisition, cancellation of delisting of many shares, satisfaction, modification of charges, amendment of constitution document, all these will be covered in that information memorandum. Mandatory content, what they have mentioned, affidavit has to be included in the resolution plan that it is eligible to submit the plan. Statement giving details if the RP and R really that party failed to implement the plan. Uh, Undertaking that every information provided is true and correct, and term of the plan implementation schedule adequate means for supervising the implementation. Resolution plan shall demonstrate that it addresses the cause of default. Submission of resolution plan. Over here, a resolution applicant may submit plan and which does not provide with the required regulations provisions, it will be rejected. Evaluation, it will come. All the resolution plans will be evaluated. Which get the highest score will be selected for the competition for base resolution plan. Approval of resolution plan. Significantly better resolution plan will be considered by COC. When no resolution plan is received, then base resolution plan may be considered. In case one or two not covered, then RP will disclose the score and base resolution plan submitter and invite them to improve the resolution plan and compete with each other. And the submitter of resolution plan will have the options. Submitter which has lower score, they will improve the resolution plan by at least a stick size. Then submitter of other plans shall have the option to improve its resolution plan by at least a tick size. So then, one by one, all the both the participant will get the opportunity to improve the resolution, and then the window will be 48 hours, and the resolution plan having the highest score will get selected, and the same will be proposed before the COC meeting. COC to for getting its approval. Uh, Resolution plan RP will submit the application along with his compliance certificate in Form 12 to adjudicating authority. RP shall forthwith send a copy of the order of the resolution plan to the participant, and the RP shall within 7 days of the order of the adjudicating authority intimate each claimant as the case may be for payment of debt, and when no resolution plan is approved, resolution profession will file termination application. Management during the process, the same existing management. Um, CD will prepare the monthly report and forward it to the COC about their details of legal proceedings, material having a material impact, detail of key contract and the other matter. RP may call for further information, visit premises, inspect assets, call for information, ask details for ascertaining the conduct. And then vesting of management. Last is under section 54J. If COC thinks that the management should be vested, should be shifted to RP, and RP can make the application with the approval of COC with 66% of majority uh, to make an application in form P14. So with this, we have completed regulations also of prepackaged insolvency resolution process. So this is all from my side. Anjali, are you there? Anjali, can we conclude the session if there is no question and no discussion as
Shall we conclude, ma'am?
Yes,
Yeah.
we can conclude because I think there's no.
Okay. Thank you very much, ma'am, for
Mm.
taking out time and addressing session on the topic unpack prepack procedures, legal framework, and practical insights. Thank you very much, ma'am, and thank you all the participants for giving your time.
Thank you, ma'am. Thank you.
Thank you.
Thank you, ma'am.